Hello everyone. In a notable ruling delivered earlier on Friday about Gachagua's impeachment, a three-judge bench was presided over to determine a consolidated petition challenging the impeachment of Rigathi Gachagua that happened in October 2024.
Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. Thank you. On a Friday, which is not a normal sitting day. Any thinking person will wonder how the Speaker of the National Assembly, a good friend of mine, senior counsel, how was he able to anticipate the likely decision of the Senate in advance? And above all, although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had time during the night to get clearance for the person he wanted as his deputy president.
In their first admission, several key decisions were delivered in regards to that impeachment, whereby a fresh supplementary court affidavit was filed by Gachagua's legal team, supportedly sworn by Dr. Dan Gikonyo. In his declaration, the medical evidence was providing a proof of Gachagua's health condition during his impeachment trial before the Senate, whereby he was actually denied the right to fair hearing to defend himself before the floor of the Parliamentary Senate. In their argument, the lawyers explained how Gachagua's medical condition prevented him from defending himself before Senate, with the court dismissing a second petition about the recusal of the initial three-judge bench, whereby the judges actually found no sufficient evidence of bias to warrant their removal.
For the Senate to impose itself on a 10-day period to conclude the business in a very rushed manner. As it was indicated by the Speaker of the Senate, they wanted to do that with military precision so that they could attain a premeditated outcome in our submission. My Lord, prayer number G is a declaration that the petitioner's right for fair administrative action under Article 47, a right to fair hearing under Article 50 of the Constitution were violated. My Lord, it has been explained in detail how the first petitioner was denied a fair hearing, so that even at a point when he fell ill, it was communicated to the Senate, and Senior Counsel Paul Muite explained to the Senate the circumstances under which he was not able to proceed with the hearing before the Senate. The Senate proceeded regardless of that particular communication.
Upon the existing judicial panel, the same High Court declined to strike out Dr. Gikonyo's affidavit, whereby, through this affidavit, Dr. Gikonyo claimed Ruto's personal phone call on the day of the Senate plenary voting to impeach Gachagua, inquiring about Gachagua's health as the Senate impeachment proceedings were ongoing before the Senate plenary. However, in a medical evidence provided by Dr. Gikonyo, the document confirms that Gachagua was admitted in Karen Hospital for quite a very severe chest pain, and required an observation for 48 to 72 hours, thus supporting the defense's argument that he was bedridden, and was denied a fair hearing. The court therefore directed the Senate and the Attorney General to file their responses before today on Monday, indicating whether indeed they would wish to cross-examine Dr. Gikonyo as a witness of this affidavit about these allegations. This ruling is considered to be an early victory for Gachagua, as he seeks to prove whether his impeachment was unconstitutionally flawed or not. However, the whole burden of proof was left for the Senate and the Attorney General herself to make a decisive determination before 11th on Monday on whether to cross-examine Dr. Gikonyo for the allegations he made through a court affidavit. However, the final ruling outcomes of this case is terribly feared to set a landmark judicial precedent about similar cases of impeachment that would come in future. Thank you and keep on subscribing.